I object. I made my kids in private. I'll raise them in private. My kids, this is a non-TANF case. Am I presumed to be innocent at this time with all my constitutional rights in full force and effect, sir? I can't, honestly, I have proof. I would like to submit into the court Exhibit A if there is no objection. I have a pay stub right here. I work 58 hours a week at $30 an hour. I come home with less than $300. I can't even make my bills.
Judge, just to let you know, Mr. Smith, it's the middle of page 1, yes. He does not want to deal with me because he does not have a contract with 4D, with any 4D workers, so he doesn't want really to talk to me. He wouldn't talk about the motion, so I'm going to submit a recommendation that the motion be denied.
Okay.
Okay, he's very difficult. I know that you read through all the paperwork. He is the individual that was talking about how he has continued to talk about that he's, he has all these constitutional rights, and he's, I don't know. I can't even explain what it is he's trying to get to or what he's trying to talk about. So.
Okay.
So there's not much I can do. He just basically told me that I'm not someone that he's willing to talk to because he doesn't have a contract with me.
He maybe doesn't want to talk with me either, but you can get Sarah. You can bring him in. And
I can get him.
That.
Yeah, and I'm in the process of sending you the recommendation that the motion is denied, but I can go and get him and bring him in.
Thank you.
Thanks.
The motion of the defendant, Father David Smith Jr., to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Sherry Zorn, as well as David Smith Jr. Mr. Smith, it is now 9 o'clock, and you are before Judge Brownick. Good morning.
Sir, I can barely hear you. I was in my vehicle where I could, and fortunately, we're back in front of Title 40 incentivization. If you can give me a second so I can make it back out to my vehicle so I can hear you, I would appreciate it.
Okay. Do you want to zoom back in then?
I'm parked right outside the door. If you give me 60 seconds. I had to come back inside because whatever just went on.
Hey, Mr. Smith, your current parenting time is alternating weekends, Friday at 5 till Sunday at 7 with your 2 children. Is that correct?
Yeah, but we work outside of the order. I mean, I got numerous evidence that we do work outside of the order. That was arbitrarily done to maximize the dollar amount pursuant to Title 4D.
Well, that's wonderful that you can both be flexible about parenting time with your work schedules and the children. That's once we work together. I'm just noting that the last order of the court, August 2015, so I do review these files in advance. I review your motions. I review the past orders. I review the history of the case, Mr. Smith.
I appreciate that.
So I'm just noting that the last order gave you specific parenting time, alternate weekends, Fridays at 5 to 7 Sunday at 7, and you could have additional parenting time, but that's what your absolute minimum. Now, in your motion, you're asking for an 80-20 split pursuant to your 14th Amendment to the U.S. Constitution. I don't know. This is not a constitutional issue. It's a state law issue, Mr. Smith. And in order for, first of all, have you talked with Ms. Zorn this morning? Do the two of you have an agreement? Certainly, if you have the agreement, you know what's best for your 2 children.
Sir,
we do not.
Okay. So, is there any merit in talking, Ms. Zorn and Mr. Smith?
I object. I made my kids in private. I'll raise them in private. My kids, this is a non-TANF case. Am I presumed to be innocent at this time with all my constitutional rights in full force and effect, sir?
Absolutely, you're innocent, but there's no criminal charges here, so I'm not sure what you're innocent of. But, Mr. Smith, no one's accusing you of anything. I'm just asking, normally the 2 parents will talk, and maybe they come to their own agreement, but that apparently is not to be possible this morning.
This is a non-TANF case getting treated as a TANF matter. I want split custody, mutual agreement, all Title 40 incentivization cease and desist immediately. I will be sending letters out today to all parties that touch this case negatively, and I'm pursuing charges 42 U.S.C. 1983 and Article 3 corporate deprivation of rights. This is arbitrarily done underneath color law. I do not consent. I have not contracted with Title 4D. I would submit into the court's blessing versus Freestone, Wehunt versus Ledbetter, sir. I don't presume ignorance on the court behalf today, therefore I'm left to believe something much more sinister is going on here.
Right, Mr. Smith, under it's not a constitution, under state law, Michigan law, there must be...
I do not acquiesce to state law, sir. I operate on federal law only.
This is a classic sovereign citizen reflex, rejecting the court's jurisdiction to feel protected. Psychologically, it gives a sense of control. Legally, it achieves the opposite. By refusing to operate within the court's framework, he forfeits the very rules that might aid him. The judge cannot address constitutional arguments when a motion fails to meet basic state requirements. A motion denied on legal threshold. Ruling ends the case before any evidence is even considered.
Right. I am going to transfer it to Article 3 court and pursue. I'm going to file an emergency injunction if I can't even make my bills. Due process has been violated. Fair Creditors Act of 1970, you guys are taking well over half of my check. I can't even make my bills. This forces me into my 13th Amendment, which is enslavement. Pursuant to no lawful money, this is a bill of pain and penalty underneath Article 1, Section 16 of the Constitution, sir. I do not consent. I do not consent. Right. I have not consented.
Your position is duly noted for the record, Mr. Smith. Mr. Smith,
thank you.
Under Michigan law, which this court is bound to follow, there must be a change of circumstances that would support a modification of custody and parenting time. In your motion, you've not alleged any change of circumstances that would warrant a review of custody and parenting time. So with all due respect, the court at this time will deny your motion to change custody and or parenting time.
I have the right to my privacy. I can't even make my bills with what you guys have done here today. I can't, honestly, I have proof. I would like to submit into the court's Exhibit A if there is no objection. I have a pay stub right here. I work 58 hours a week at $30 an hour. I come home with less than $300. I can't even make my bills.
That's an issue of child support, Mr. Smith. You're asking to modify custody and parenting time today.
I am not here. I'm here to
support.
Just
file such a motion.
4D. Sir, do you have a contract in dispute with me? I'm asking the court, Ms. Zorn, to place into the court all evidence she has partied on my contract. If not, I motion to dismiss with prejudice, failure to state a cause of action. This goes against my Constitution, sir. I understand Michigan law, but it must be in compliance with the Constitution. This has violated me as a man numerous times, and now I can't even make my bill. I'm asking you to give me 50-50 split of my kids. I made them in private. I will raise them in private. There is no need in dispute, nor has there ever been. You know what, sir, underneath Article 1, Section 13, Paragraph 5, I want to face my accuser. If we could please swear Ms. Zorn in so I could face my accuser here today, sir, I would appreciate it.
All right, to Mr. Smith, perhaps you should consult a constitutional lawyer. This matter is guided by state law. The court has made a decision. There's no change of circumstances that would warrant a change of custody and parenting time. The court will not argue over you, Mr. Smith. So that will conclude, sir. You can zoom out.
Of this case.
An order will be entered. All right, Mr. Smith, consultant attorney.
Do you have a predetermination of this case, sir?
Okay, this matter is concluded. You can zoom out. Have a good rest of the day. Josh? Are you still there, Mr. Walker?
Yes, Your Honor.
Can you just a motion to change custody / parenting time is denied because you're sort of asking for both?
Yes, I can.
So maybe we can just cover both bases and just squeeze in maybe a custody / parenting time. Can you put a defendant's motion so it's real clear in there? We know who the motion is. Defendant's motion to modify custody / parenting is denied for the reason there's been no alleged change of circumstances. Maybe you can spell it out so if he wants to appeal to the Court of Appeals.
I can do that.
This case isn't about hostility or misunderstanding. It's about misalignment. The court repeatedly signals what matters: jurisdiction, procedure, and a required change of circumstances. The defendant responds with ideology, not compliance. Sovereign citizen language can feel empowering. No contract. Article 3, I do not consent, But courts don't operate on belief systems. They operate on legal thresholds. Miss the threshold, and nothing else matters. Here, the motion fails before substance is even considered. Not because parenting time is unimportant, but because the request never meets the entry requirements. Arguing constitutional violations in a family court motion doesn't escalate the issue. It changes the subject. Judges don't chase side arguments. There's also a strategic cost. Each refusal to engage with applicable law undermines credibility, and every irrelevant citation signals that future filings may follow the same unproductive pattern. Appellate courts don't relitigate ideology. They review whether the law was applied correctly. The most consequential decision here wasn't the denial. It was the choice to frame the case around sovereignty instead of legal standards. Once that choice is made, outcomes narrow quickly. This isn't about winning or losing custody today. It's about the path taken and the limits it imposes.